put it in the order is that if you have parenting time, that we're going to end up in the same situation where you're not returning the child based on what happened before.
Right. But I would never do that, Your Honor. I've been warned. You're warning me. I understand that. I understand that I have to follow that order until that order is changed. I thought that when that order was put in effect, Your Honor, and I filed papers to modify that order, I thought I read in that paperwork that if it was a new order, it didn't apply. Like the order was brand new. I was under the understanding that it didn't apply. You know, and like I said, she never asked for our son back. I mean, she, you know, just don't know. Okay. I'm just all I know is I will follow the order every other weekend, and that this is killing me and it's hurting my son. I know my son is hurting from this.
All right, thank you, Mr. Schrock.
Thank you, Judge. I appreciate the fact that you reviewed the referee hearing, Your Honor, and I think that in doing so, you probably find that Mr. Brewer's statements today are disingenuous with this court. I mean, I had the distinct impression that he knew that there was an order, he knew that he was in violation, and he knew that he wasn't going to have to face the music until February when it came to returning the child to his son. I mean, he was sneering to the court. He was, you know, he loved the fact that the date was several months out from when we were last before the referee. So his suggestion today that he's going to follow the order and it was just a mistake that he had made in the past, I think is without merit. In reviewing your order, it looks like it's your expectation that we'll have an evidentiary hearing before the referee in February. And at that point, the referee can make a recommendation as to what's in the best interest of the party's 4-year-old son. So I would ask that the court essentially allow us to have that hearing in February and allow the referee to make a recommendation and see where we go from there. The only other thing I'd mention as kind of an aside is that Mr. Brewer did file his objection in a timely fashion. Unfortunately, he didn't serve it on me as counsel of record. So my calendar was open and I was able to attend today's hearing, but I wasn't aware of the objection until sometime after it was filed and my client brought it to my attention. So that's just an important piece for Mr. Brewer to understand if he's going to represent himself in these proceedings, that when he does file anything, it needs to be filed with counsel of record also.
All right, thank you. Mr. Brewer, anything you wanted to say in response to that?
Well, the only thing I had asked the county clerk and she advised me just to mail it to her known address. So from now on, should I just file papers to his office? Is that what he's saying?
Well, yeah, he needs to get a copy of everything that's filed.
Okay, I'll make sure he does.
So, all right. So again, I did review the hearing that was before the referee, and it, you know, I watched it, and it was made very clear, Mr. Brewer, that you know, that you were supposed to return the child, what the current order was that was in place.
Okay.
And my interpretation of that hearing was that you were going to refuse to do that, even though you were aware that.
Excuse me, I'm sorry, Your Honor. I did not mean to interrupt you. Yeah. Your Honor, if the referee that day would have told me to return my son, I would have returned him. I understand what you say goes. There is no doubt about that.
Yeah. So, I mean, I watched it. I saw everything that was said, and that's my impression of it. And so that leads me to continue to have the concern that I had at the time that I entered the order, that if you have custody again for parenting time until this is worked out, that we're going to wind up here with another issue, a motion from Mr. Schrod. I'm just not going to put everybody in that position of creating an issue. So,
okay.
So
right.
Court's order. I've heard your objection. Court's order from December will remain in place. The parties will proceed to hearing as currently scheduled, and we'll go from there.
All right. You have a good day, Your Honor.
All right. Thank you. That's all for this hearing. All parties are free to disconnect at this time.
Thank you, Judge.
Ma'am, I'm going to need you to unmute and identify yourself, please.
Yes, hi, my name is Irish Nolasco.
Irish and Alaska. Okay, thank you.
You're welcome.
All right, Mr. Deshane, are you able to hear me okay?
Yes, Your Honor.
Okay, we're on the record in Alaska versus Deshane, case number 2018361. The record should reflect both parties are connected, along with Ms. Kraus from friend of the court. Ms. Kraus, can you tell me the status of this file this morning?
The referee's hearing on November 20th, the referee did recommend contempt. Based on his testimony, the defendant has a balance exceeding $20,000. He has the ability to pay out of currently available resources, and he has recently made a payment on another domestic relations case. He has not made diligent effort to pay all or more significant portion of the amount owed. He was given the option to make a purge payment before today's hearing in the amount of $2,500. This morning, Sean did present at friend of the court to make a $1,000 payment. He has also, in the meantime, requested a review of support. With that review, he submitted limited information, so it would be beneficial for friend of the court to have some more information on how to go about the support recommendation for his income.
Okay. All right, Ms. Nolasco, was there anything you wanted to say in this matter?
I know the last time we were in court is that it's, you know, the 2,400, and then he hasn't had any kind of payment at all before that. I understand that he was like, he had some kind of circumstances. So right now I'm just trying to see what we can do about this.
Okay. All right, Mr. Deshane, so the court is going to set this over for 30 days. Although, you know, you didn't make the $2,500 payment, you did make a $1,000 payment. So the court is going to set this over for 30 days, and the court will make a determination as to the contempt at that time. Ms. Kraus, does he need to contact friend of the court regarding the additional information, or is that something that you can state for the record here today?
If I could state for the record, the questionnaire that he did submit had a lot of information blank. This morning, he did submit some information from like 2019 through the present, which he had indicated on Friday that he hadn't had any income. But today on the paperwork, he said he completed a flooring job that he received $2,000 for. So I'm looking for his income amount to input for that calculation to get it out.
Okay. Mr. Deshane, can you address that for us?
I'm not sure which part, Your Honor. I'm sorry. I was listening, but I'm not sure what exact part you want me to address.
Can you provide that?
Income.
Yeah, can you provide that information to the friend of the court?
I did this morning. I wrote some stuff down on a paper. I could go over it again if you want, but so as of November 19th, or as of November 9th of this year, I broke up with my girlfriend that I was living with, and now she is keeping all of my stuff, and I am suing her. We go to court next Monday. So as of November 9th, almost 60 days ago, all of my tools were taken from me, and I can't even work. So I was just able to complete a flooring job with the help of some other guy and his tools. I made $2,000, and I turned over $1,000 of it this morning. I just got that money on Saturday. So when I talked to Ms. Kraus on Friday, I did not have that money. So I didn't count eggs that weren't hatched, I guess, Your Honor. And then this morning I paid half of the money that I received.
So Ms. Kraus is indicating that you left a lot of information blank on that form that you turned in. And then Ms. Kraus, again, for the record, can you state exactly the most important information that you need from him?
His gross income monthly, so we can do the recommendation.
So
Okay.
Mr. Deshane, you need to provide that in writing to the friend of the court. Otherwise, nothing's going to get adjusted. You won't even be able to have it considered. Okay.
Yes, sir. Can I say one thing that I would like to be on the record, please?
Yeah.
So obviously I knew that I had a son and that I wasn't paying child support, but I had never gotten any information. In 2020, I would never received any information when this child support stuff started. I didn't know anything about owing child support obligation until less than a year ago. But in 2020, I was working a job making $14 an hour, paying child support for 2 children right here in Gaylord. So what I don't understand, I can't seem to calculate it in my head how this number was ever even brought up. My obligation for my son here in Gaylord is $179 a month. Then, so how does the next kid, the third kid, be triple? On top of that, I'm only making $14 an hour. So I feel like the $20,000 number is inaccurate. And so I don't feel like it was calculated correctly, because I don't believe it was based on $14 an hour at the time of the case. So I feel like I owe more than I should. And it seems unfair, I guess. And I don't know how better to explain it. But I do believe I owe money. I'm not stating I don't. Oh, I know I owe.
Well, if you want to challenge the amount, there are ways to do that. You just telling me that here on the record, is not going to be sufficient. You need to challenge the amount. You're going to need to file a motion in the front of the court. You may need to get an attorney to help you with that. But if you want to challenge things going all the way back to 2020, you're going to have to do a lot more than just make a statement like this here on the record, because I have no idea, based on what you're telling me, whether it's appropriate or not. So that's something that you need to be proactive about, because based on the information that we have, and the court has followed the law in terms of what it needs to charge based on the information that was provided to us. So if you think that's wrong, or you weren't provided appropriate notices or so forth, then you need to be proactive about that. Start filing some motions to get things changed. Otherwise, it's not going to change. And just saying it on the record is not sufficient.
I did file a motion. I did file a motion regarding support. That's in the works right now. I got another one this morning when I was at their office. I will be more proactive, and I apologize for not being more proactive.
Yeah. So, if there was something wrong, we'll look at it based on what you filed. And obviously, if there's a mistake made, we'll correct it. But if there's not, then we're going to go forward. So either way, you need to provide the information that Ms. Krause has indicated within the next 30 days. Can you make another payment within the next 30 days?
I'm not sure, because I'm fighting another child support case this week that also needs to be addressed. So I don't know for sure, but I will definitely try. If all of my personal property wasn't being held by my ex-girlfriend, I could sell my personal property and make payments. So I'm kind of screwed in the sense that my ex is being spiteful and holding all of my stuff. So I can't even sell my assets to even try to make any payments on, because I have nothing right now, which sucks. And that court case is on Monday. I'm suing her for $7,000 because she has all of my tools. I've been a flooring guy for 20 years. I'm a felon. I can't go get a job at just most places. So I've been doing my own little flooring gig for a long time. And now I just can't do it because all my stuff's gone.
Ms. Krause, is there a monthly amount still charging on this?
$513.
$513. Okay. All right. So the court's going to order, number one, that you provide that information within the next 30 days. The court's going to order that you make a monthly payment within the next 30 days. We'll set this for hearing at that time. If neither or either of those things is not done by that hearing, then the court will proceed with contempt sanctions, and we'll go from there. Ms. Krause, anything else we need to address on this file today?
No, thank you.
All right, thank you. Both parties are free to.
I have a question.
Yeah.
Hi. We did all the paperwork. If you can go all the way back to the 2020, it was actually because of COVID, it was pushed back. So I believe that, everything that he gave, I have the paperwork that he put, how much he makes and everything like that. And I understand that there's the two other kids that he has to take care of. I understand that fully. Obviously, that's something that he has to take care of, but he also has our child that he has to take care of. And I feel like that amount that he's contesting is actually the right amount for it. It's actually less because it got pushed with the COVID. My case was not heard for like pretty much 2 years, I believe so. And he hasn't paid anything. And we, everything that all the question that, all the paperwork that the court asked me to do, I gave everything that I have. And I haven't even done any kind of, it's been what, my son is 10 years old now. The last time I did the very first time, he was what, 3 or 4? So his actual amount is actually more than what he needs now. He needs more. It's just I'm not even doing that. And that's why I don't know, like, if this does not, 30 days from now, if it doesn't go, do I get any kind of paperwork that we are doing another hearing?
Yes, you'll be notified of that next hearing, and you'll be able to appear as you have today. And, my point to Mr. Duchesne is, as far as the court's concerned, the amounts are correct and everything's been done correctly. If he can bring forward some kind of evidence through his motion that it hasn't, then we'll have to take a look at that. But as it stands right now, it's not going to change unless, the burden's on him to come forward and show that something has been done wrong or calculated incorrectly.
Yes, Your Honor. And then also the, what is it called? The amount for the next 30 days, is it just the rest of the 24 or 2,500 that he owes not to be on contempt?
Right now, the court's requiring him to make the normal monthly payment and provide the information. If he doesn't do that, then the court will proceed with contempt.
So it's the regular monthly payment that he owes.
Right. What I'm trying to do right now, Ms. Nolasco, is keep some money flowing to you. If that doesn't happen, then at that point, again, we'll proceed with contempt and the court will likely order jail time for Mr. Duchesne. What I'm trying to do is just keep some amounts flowing to you. And, because that's going to do you more good than him staying and being in jail. But if he doesn't pay, then if he's not paying, then there's no reason not to put him in jail. So the idea here is,
I understand.
Yeah. Okay.
Yes. Okay.
All right.
Okay. And then also that the 1,000 that he pays, is it something that's coming to me, or is it for the court?
Ms. Kraus, can you address that? It should be going to you.
Yeah, it would take 3 to 5 business days. There should be something coming down, but it's not going to happen today.
Okay, sounds good. Thank you so much.
Okay, thank you. All sides are free to disconnect on this case.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, Ms. Dobbins-Beck, are you able to hear me okay? Ms. Dobbins-Beck, are you able to hear me?
Yes, can you hear me?
I can, thank you. Okay, we're on the record in Butts versus Dobbins-Beck versus Butts, case number 2218954. The record should reflect Ms. Dobbins-Beck is present here today by video. I do not see Mr. Butts present. Ms. Kraus, can you tell me the status of this file today?
This hearing has been adjourned 4 times, most recently from December 2nd to monitor the income withholding order. And the defendant was to make payments through the disbursement unit, meeting his monthly obligation and money towards the arrears until the income withholding is withheld from his paychecks. There has been a payment received this in December. Since the last hearing, it was a self-pay one in the amount of $200. His monthly obligation is $370 and the arrears owed as of today is $9,008.62. There has been no payments received from the pending income withholding.
Thank you. Ms. Dalvin-Speck, is there anything you wanted to state in this matter?
Do you guys have his correct employment on file?
I have no idea. We have whatever he's provided to us, but I don't know whether that's correct or not. He's not here to confirm it, or, you know, we can tell you. Ms. Kraus, can you tell me what the information is that we have?
She could provide it. I don't know if we could provide, are you requesting the information then,
Yeah.
Your Honor?
Where do you think he's working, Ms. Dalvin-Speck?
I mean, I know he's working at Mech and Vanderbilt, but I don't know if he gave you guys the correct address.
All right, what do you know what the address is for it?
1 second. It might mute me. Hold on. Okay, what I have is 8276 Ewell Street, which is Yuill Street, Vanderbilt, Michigan.
All right, and that's his current employer?
Yeah.
Okay, is there anything else that you wanted to state in this matter?
No.
Well, Mr. Butts is supposed to be here today. He's not here. Clearly, he's not providing or confirming information. That's his responsibility to provide the correct information and make sure that it's correct. It's really not your responsibility, Ms. Dalvin-Speck. It's certainly not Ms. Krause's responsibility to chase it down. So the court's going to issue a bench warrant for Mr. Butts, primarily for his failure to appear today. So the court will proceed further on this matter once he's arrested and brought before the court. Ms. Krause, anything else that we need to address on this file today?
No, thank you.
Ms. Dalvin-Speck, do you have any questions at all?
No, not today.
Okay. All right. Thank you. You're free to disconnect at this time.
Thank you.
Mr. Hildebrandt, are you able to hear me okay?
Yes, sir.
All right, we're on the record in Brink versus Hildebrandt, case number 11140050. The record should reflect Mr. Hildebrandt is present today by Zoom video. Ms. Brink has not appeared today. This hearing was set for 9 a.m. It's now 9:26. She is not present. Ms. Krause, can you tell me the status of this case today, please?
The plaintiff has a support obligation of $197 and the total amount due is $9,715.16, which includes this month's obligation. There has been no payment since the last hearing when the plaintiff was found in contempt and served 45 days in the Otsego County Jail and was released on October 9th. The last payment that was received was from a prior income withholding in the amount of $206.47 in February of 2024. There has been no communication with the plaintiff.
Thank you. Mr. Hildebrandt, was there anything you wanted to say in regard to this matter?
Not regarding the support, but I do have a couple questions otherwise.
Okay, what are your questions?
It's actually about Chelsea's mental health records to further diagnose my daughter and the issues that she's got. I was just curious how I go about getting those, because I know they've been brought up in court before, but just I don't know how the proper channels to go through to get that. I was looking if you could provide me a little guidance on that.
Are they documents that have been admitted as part of prior court proceedings as exhibits?
I believe they were, I know they were brought up and discussed in court. And that gave, when we were doing our custody here, that gave Bill's lawyer the opportunity to bring them up and discuss them in court.
Okay. Ms. Kraus, I saw you kind of nodding your head. Was there anything that you wanted to add to this?
Yes, it is brought to my attention that the plaintiff is actually in Otsego County Jail as of yesterday. I didn't check the inmate list this morning. I apologize.
Okay, all right. Okay, so Mr. Hildebrand, to answer your question, first of all, if those are part of the court file, you can come to the clerk's office here in Otsego County and you can go through the file. If those records are part of the file, like if they've been admitted as part of prior hearings, then that's a public file. So you're more than welcome to come in and see what is in the file that you can review. To the extent that they're not part of the file, that is something that would require me to give you legal advice. I can't ethically do that.
Okay.
So you would have to gather some more research on your own, or maybe consult an attorney as to how you would be able to obtain those records.
Okay.
Because they're covered by all kinds of different protections regarding confidentiality and so forth. That doesn't mean you wouldn't have a way to get them. It would be something that you would have to consult an attorney about or research.
Okay, thank you, sir.
Okay. All right. In terms of going forward, although we do have that additional information, the court's going to issue a bench warrant for Ms. Brink. Since we do have her lodged already, Ms. Kraus, I think what we'll try to do is set that for a arraignment hearing on Wednesday when I have my criminal docket. Mr. Hildebrand, did you want to be present for that?
Yeah, please, if I could.
Okay. When we get the date and time of that, we can contact you. Ms. Kraus, do you have Mr. Hildebrand's contact information?
Yes, we should.
Okay. So Mr. Hildebrand, we'll let you know the date and time, but I'm going to try and get that on the docket for Wednesday at some point, and you can join by Zoom as you're doing today.
All right. Thank you. Yes, sir.
Okay. All right. Thank you. You're free to disconnect at this time, Mr. Hildebrand.
All right. Have a good day.
Thank you. All right. The last case that I have on the show cause docket is Snyder versus Briggs. That's case 1415661. Neither of those parties has appeared here in court today. Ms. Kraus, can you tell me the status of that file?
On November 20th, the referee recommended contempt. He had indicated, based on his testimony, he has not made a diligent effort to pay all or some portion of the amount due. He has the capacity to make payments. The defendant had not made good faith efforts to make payments. A purge payment was identified that could be made of $2,500 to dismiss that. The payment was not made. The monthly obligation is $342. The total owed is $23,718.56.
Okay, based on Mr. Briggs' failure to appear, the court will issue a bench warrant with that same purge amount, and we'll proceed further once Mr. Briggs is arrested and brought before the court.
So $2,500, correct?
Correct.
Okay.
Yes. Did you have any other cases on the show cause docket that I missed?
I do have one for Mr. Dougal, but that would be in person, so I will be making my way down there shortly.
If you just want to stay signed in, you can be present by video.
Okay, I appreciate that. Thank you.
We're running behind already, so.
No, I appreciate that.
Okay, so just stay in the line, and I've got a case before that one that I need to take up, so it'll just be a few minutes. Looks like we've got all the parties connected here. We'll go on the record. This is Cotton versus Cotton, case number 2319201. If I could have counsel put your appearances on, starting with plaintiff, please.
Good morning, Your Honor. Jennifer Deuce-McCoy on behalf of Keela Cotton, who is present with me in my office. Good morning, Your Honor. Katie Komorowski on behalf of the defendant, Ty Cotton, who is present with me in my office.
Okay, we've got a number of matters set for hearing in this case today. The first one I'd like to address is the objections to the proposed order arising out of our prior hearing back on November 4th. I did have a chance to review the proposed order submitted by both sides. Ms. Komorowski submitted her order. It was Ms. Dukes-McCoy that objected to that, and she submitted an alternate order. I also had a chance to review the video of the November 4th proceeding, and looking at the two orders and in light of the record that was made, the court finds that the order submitted by the plaintiff, Ms. Dukes-McCoy, more closely comports with the court's ruling. And so the court is going to enter the order as submitted by Ms. Dukes-McCoy. So that addresses the objection and the issue with regard to the order arising out of the November 4th hearing. The next matter that we have is there was a hearing before the referee, I believe on November 13th. On November 14th, the referee issued a recommended order, which Ms. Komorowski filed a timely objection to. And so we need to get that set for hearing. Ms. Komorowski, can you tell me, I haven't had, I'm going to be reviewing it, but I did not have a chance to review yet the transcript from the referee hearing. Can you tell me how long that hearing was?
Yes, Your Honor. The hearing lasted, it was at least half a day. It started after 1 o'clock and we went after 5.
Okay.
I believe the plaintiff, she had mentioned at the beginning of that hearing that she had other people she wanted to call and there wasn't enough time.
Okay. So just so both counsel are aware, typically the way that the court addresses de novo hearings on objections is that the court limits the record to either new evidence that has arisen since the referee hearing, or witnesses that there was not enough time to be heard at the referee's hearing. I do not have the parties, present the same evidence that was presented at the referee hearing. I review the record and I take that into account along with the exhibits that were entered. So it's really more of a supplementation of the referee's record. So in terms of, with that in mind, Ms. Komorowski, how much time do you think we would need for the hearing before this court?
Your Honor, with that in mind, I think another half-day hearing would work.
Okay, Ms. Dukes-McCoy?
I would concur, Your Honor.
Okay. Do either of you need any particular period of time to be ready for that hearing, or do you just want the court to schedule it at the next available date? Ms. Komorowski?
I would like some time to get ready for that hearing, Your Honor. If we could have, at least 30 days to be ready before the hearing's set.
Okay, Ms. Dukes-McCoy?
I don't have any objection to that, Your Honor. I'm guessing the court can't schedule something that quickly anyway.
Okay, so we'll set this for a half-day hearing at the court's next available date, which likely, Ms. Komorowski, it's likely going to be in the 30 to 60-day range, I believe. So we'll set it for a half-a-day hearing. And again, counsel is directed to follow what I've indicated, which is limit their proofs to additional evidence that's arisen since the referee hearing and any witnesses that there was not time to testify to. Okay, in terms of scheduling on the objection to the recommended order, Ms. Komorowski, anything else that we need to address from your standpoint?
Not in terms of scheduling for that, no, Your Honor.
Okay, Ms. Dukes McCoy?
No, Your Honor, thank you.
Okay, and then we have Ms. Komorowski, your motion to disqualify the referee. I did have a chance to review your motion as well as Ms. Dukes McCoy's response to that. Ms. Komorowski, any oral argument you wanted to present today on that?
Yes, Your Honor. Typically, I would hesitate to file that kind of a motion because it's pretty, a serious allegation. However, in the parenting time that was subsequent to the November 13th hearing, the minor child in this case spoke with his father and indicated that the referee's son is in his same grade, attends the same school. He's very good friends with him, has met the referee outside of school. And in the conversation that my client had with his son implied that he felt that he had this relationship with the referee that would have had an impact on the case. The child asked about child support during that parenting time, how much money is his mother going to get, and all this this type of questioning to his father that made his father feel uncomfortable about answering and discussing with the child. So we filed this motion for disqualification based on the facts that the child had presented to the defendant during his parenting time and, made the defendant feel as though the referee may have issued a prejudicial determination against him in that hearing.
All right, thank you. Ms. Dukes McCoy?
Thank you, Your Honor. As we stated in our response to the motion, counsel's statements are not evidence. They're reliant on hearsay statements of the child. The motion was not supported by an affidavit as required by the court rule under which the motion was filed, MCR 2.003. So it's procedurally improper. Further, we do not feel that there was any bias shown. There is a very heavy burden on the party claiming bias or claiming a problem with the fact finder to show that there is that bias, and that hasn't been met. Again, we don't even have an affidavit in support of that. A verified pleading is not the same as an affidavit. These statements are inadmissible, so they're not something that can be used essentially to support that anyway. So we feel that the motion is improper and that it should be denied.
Thank you. Ms. Komorowski, anything in response?
Well, I understand that Ms. Dukes McCoy is making a differentiation between a verified motion and an affidavit. However, in either event, my client did verify that this was his statements that he was making to the court, regardless of whether or not a notary verified it or not. Under the Michigan rules, an e-signature is a valid signature to be had to support a motion for, a verified motion. So that would be my response to that.
Okay.
As far as the hearsay goes, the child is not a party to the case necessarily. And so, I think it would be improper to have the child make a affidavit statement about this to the court. Certainly the court could have a in-camera review with the child to ask him about it if it was needed.
All right. I found this to be an interesting motion from the standpoint that, at least in the 12 years that I've been on the bench, I've not seen a motion to disqualify a quasi-judicial officer like a referee. And so I did some research. I know both attorneys did as well. And neither of you cited to any authority, really as to how referees should be treated. And I couldn't find anything either really that directly applied to request to disqualify a referee, there is some case law regarding other quasi-judicial officers like administrative law judges, different boards with certain authority over public matters and so forth. And one of the parallels that I found is generally with quasi-judicial officers, they are treated for purposes of things like immunity, the same as a judge is treated. In terms of ethical standards, they apply to those officers just as they would to a judge. So while there isn't any direct authority saying that the court is to follow the same court rule and the same standards to disqualify a referee as it would a judge under 2.003, it certainly, to me, makes sense that if a quasi-judicial officer like that is treated as a judge for all those other reasons, there's no reason why they would be treated any differently for purposes of disqualification. So I say all that to say that I do think that 2.003 is the correct court rule to analyze this under. And so looking at the provisions of 2.003, I think we do have an issue here procedurally. It's not the same one, although I think Ms. Dutzman-Coy does raise a good point regarding the affidavit issue. But I think there's a bigger procedural issue here, because if the court is going to treat the referee as a judge for purposes of disqualification and follow 2.003, under 2.003 D3A, court will state that the challenged judge should rule on the motion first. And so that leads me to find that this should be brought before the referee, and the referee needs to make a decision about disqualification. Because number one, the court rule says it. Number two, it makes sense that the challenge judge should decide motions like this, particularly where there's an allegation of, the appearance of impropriety or personal knowledge of disputed facts, which are some of the grounds that were listed by Ms. Komorowski. And that's because the challenge judge knows what those relationships are. I have no idea what Mr. Legal's connection to this case is or isn't. Just as when I get motions to disqualify me based on relationships that my family members have with potential people involved in the case, I know what those relationships are, and I can state for the record whether I believe there are grounds for disqualification or not, and I can describe for the record, make a record as to what those relationships are. I can't do that on behalf of the referee in this case. So for those reasons, it also makes sense that the court rule provides that the challenged judge is the one to hear the motion first. Then that judge can either grant the motion, in which case it's a non-issue and everybody goes forward unless the other side wants to appeal that. But if the challenge judge then denies the motion, then it goes to the chief judge, which in this case would be Judge Hunter. And then Judge Hunter has a record. Mr. Referee Legal will put on the record why he thinks he shouldn't be disqualified, and it will address those relationships. And then Judge Hunter can review that upon request of the party pursuant to court rule and decide whether he thinks that those relationships should disqualify Referee Legal. So the court finds that it should follow that court rule. There's no reason if we are going to treat the referee as a judge in this case for purposes of disqualification, there's no reason not to apply that rule to the referee just as we would to any other judge. So the court is going to deny the motion on procedural grounds, not on its merits. To the extent, Ms. Komorowski, that you want to pursue disqualification of the referee, then that would be a motion that would need to be filed before the referee. If Referee Legal grants that motion, then all future hearings would be conducted before me as the presiding judge. If Referee Legal denies that motion, then Ms. Komorowski, pursuant to court rule, you can request that the chief judge hear that motion, and then that'll decide it. So that's how we'll proceed with regard to that. And none of that is going to result in any kind of delay, because we can still proceed with hearing the objections to that order. And Ms. Komorowski, to the extent that you want to, again, pursue disqualification, you're going to have time in the interim to pursue that, and it won't delay any matters in this case. So again, the court's denying the motion on procedural grounds. Ms. Komorowski, I will ask that you present an order under the 7-day rule or with stipulation as to form on that. And then in terms of, this was also set for a status conference today. I think our scheduling of the de novo hearing kind of addresses the status conference aspect of this, unless Ms. Dutzman-Coy, on behalf of plaintiff, was there any other scheduling matters for purposes of a status conference that you wanted to address today?
No, Judge, because I think the court was wondering essentially for the status conference, these parties were prepared to enter a judgment of divorce before we had these child-related issues come up. And so we're still obviously working through those. So I think that does handle that question about where are we in this case, so.
All right, thank you. Ms. Komorowski, anything further from your side today?
I do, Your Honor. I don't. So in the last month, I've received information from the plaintiff that she does have a 401k and that she did not disclose that prior during discovery, and she did not disclose it before we mediated property settlement. And so I would like if the court would reopen discovery, then I would like to do a subpoena for her 401k records to find out how much money we're talking about that didn't get divided.
All right, Ms. Dutzman-Coy.
Your Honor, my client forgot about this 401k because it's such a small amount of money. She forgot she even had it. When Ms. Komorowski asked me about it, I gave her information on a voluntary basis. I even offered to subpoena the records. I don't have a problem with extending discovery. I think it's sort of silly to argue over $500, but I understand the concerns of the defendant. Frankly, I would subpoena the records myself, but if Ms. Komorowski chooses to do that, that's fine.
Okay, so Ms. Komorowski, if you can, along with the order regarding the motion, if you can put in that order that discovery will be reopened for 60 days, limited to issues regarding plaintiff's 401k.
Okay, thank you, Your Honor.
All right, thank you. That's all for today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, can you check with Jordan out there? Next one is supposed to be in person.
Out here.
Yeah. And then Casey, I'm just going to need you to move that over.
Yeah.
If you can just kind of angle it slightly. So there we go. Thank you. That corner, yes, there we go, perfect, thank you. All right.
Okay.
Ma'am, are you Miss Clear?
I am.
Okay, you can be seated, thank you. All right, okay, we have Ms. Krause. All right, so we're on the record now. This is Clear versus Duval, case number 1717029. The record should reflect Ms. Clear is present here in the courtroom today. We have Mr. Truce, you're here on behalf of Mr. Duval, is that correct?
That is correct, Your Honor.
Okay. And then we have Ms. Krause on behalf of friend of the court. This was set today as a hearing on contempt. had any contact with Mr. Dugal?
I'm not, Your Honor. We sent mail to the address that front of the court provided to us. I contacted him at the number the court provided. I reached out at that number. I also reached out to front of the court to see if they had updated contact info. They provided a different number. I've never got any answer or response from any of my correspondents.
All right. Ms. Kraus, do you have any kind of information or updates on this file?
Yes, it would be to address two things. One would be to address the contempt and then forfeiture of the bond that was posted in the amount of $1,600. We would request that be forfeited to front of the court to be processed for his account balance.
Okay. Ms. Clear, is there anything you wanted to state today?
All I know is that he's planning on moving to Tennessee and leaving.
Okay.
To get away, so he doesn't get in trouble anymore.
Do you have any more detail as to where he's going? When?
Tennessee is what he told his daughter over a text message.
Okay.
And that he was moving very soon.
Okay.
So I know he's still in Harbor Springs. He's not in the old address anymore because he get evicted and everything. So I don't know exactly where in Harbor Springs, but I do know he is still up in that area right now.
Okay. All right. So the court's going to order that the bond that was posted be applied to the account. So when can Ms. Clear expect to get that money, Ms. Kraus?
It may take a little bit of time because the money would have to be received to our office, and then I think it's addressed at one of the county hearings to do that. So unfortunately, I don't know exactly when that money would be available.
Okay. All right. Well, we're going to get the process started so that you can get that as clear. Based on Mr. Dugal's failure to appear today, the court will issue a bench warrant for his arrest, and we'll proceed further once he's arrested again. Ms. Kraus, what would be the purge amount on a bench warrant?
Let me look 1 second. So 25% of the balance before the bond amount?
Yes.
It would be $1,600.
So the court will set bond at $1,600 again. And we'll proceed further once Mr. Dugal's arrested and brought before the court. Do you have any questions at all, Ms. Clear?
No.
Mr. Trush, anything further for the record?
So there's still an open contempt.
Well, yes. There's
Okay.
still an open contempt charge, and then we've got an additional contempt for his failure to appear today.
Okay. I'm just trying to make sure I understand what I need to do from a bookkeeping
Yeah,
standpoint.
so the new bench warrant will address his contempt for failure to appear today and a purge amount of $1,600 based on their rearage. The old contempt charge is still active because we haven't been able to reach a resolution on that.
Understood.
Okay, thank you. That's all for today.
Thank you.
Sorry.
Your Honor,
Yes.
I'm gonna mute myself and shut the video off because there are some hearings that, in case there's questions for friend of the court, I could be available if there's questions, okay?
Perfect. Thank you. I appreciate that.
Yep, you're welcome.
You can move that podium back. Thanks, Jordan.
Yes, yes, sir.
That,
Perfect.
yeah, thanks for that.
Flashing on YouTube's gonna get busy.
I'm so sorry. 45. DB.
on the Samsung device, sir, can you tell me your name, please?
David Doobie.
Mr. Doobie, okay. All right. And ma'am, you're Darcy Fuzi Doobie, is that correct? Okay. All right, we're on the record. This is case number 2419905, Doobie versus Fuzi Doobie. This is, the record should reflect both parties are present here today for this hearing. So this is a scheduling conference. I know that parties are already kind of moving forward in terms of custody, parenting time, and support with the friend of the court. The purpose of this hearing is to determine whether there are issues regarding the division of any assets or debts of the marriage, so kind of the property side of this divorce. So Mr. Doobie, as a plaintiff, I'm going to ask you first, are there issues that the courts needs to decide, or have you been able to reach any kind of agreements with Ms. Fuzi Doobie?
No, we've agreed on everything.
Okay. So there's no issues regarding the division of any assets or debts from your standpoint?
None at all.
Okay. Ms. Fuzi Doobie, do you agree with that?
I do.
Okay. All right. So as you're both probably or maybe aware, it looks like this was filed in November. When there are children involved, there's a 6-month waiting period. So because there's no issues regarding the division of any assets or debts that the court needs to decide, I can just set this for a final hearing at the expiration of that 6-month period, which would be around April. And then what you both will need to do prior to that hearing is to prepare what's called a judgment of divorce. That's a form that you can get where you got all the other forms. But it's the final document that needs to be filed in the case and signed by the court. So you'll need to fill that out and provide that to the clerk's office prior to that final hearing date. Also, once things are settled regarding custody, parenting time, and support, you'll need to get a final order from the friend of the court and submit that along with that judgment of divorce as well. If both of those are filed prior to the final hearing date, then we can finalize the divorce on that date. And then the court will send you both notice of the date and time of that, just like for today. And it'll be by Zoom, just like we're doing today. Mr. Doobie, do you have any questions about that?
Nope.
Okay. Ms. Fuzi Doobie, do you have any questions?
No, we've actually already prepared that judgment of divorce online, so that can just be turned into the county clerk's office at any point in time, correct?
Well, there'll be parts of that dealing with custody, parenting time, and support.
Oh, okay.
That may need to be filled out, and the friend of the court's going to want to see that judgment of divorce as well.
Okay, so we'll do that following our hearing with them next week then.
Correct. Yep. If everything gets resolved. Yep.
Okay. Thank you.
Okay. All right. Thank you. Again, the court will send you both notice of the date and time of that final hearing, and you're both free to disconnect at this time.
Thank you so much.
Okay, Ms. Anderson, are you able to hear me okay?
Ma'am, Your Honor.
We'll go on the record in Lee versus Lee, case number 2419864. The record should reflect Ms. Anderson's present on behalf of Ms. Lee, the plaintiff. This was set for 10 a.m. It's now 10:05 by my clock. I do not see Mr. Lee present in the Zoom waiting room. This is set for a status conference today. Ms. Anderson, can you tell me where things are at from the plaintiff's standpoint?
Yes, Your Honor. I've tried to make contact with Mr. Lee. I've emailed him. I've also phoned him and left him a voicemail, letting him know I just want to talk about where we're at and what issues need to be decided in this case, and I've gotten no response. So our position is still that there's no real property, there's no vehicles. We're literally looking at actual personal possessions and household items. And my client has made an offer individually to Mr. Lee on some of those things. So I don't think we need mediation here myself. I think there's very little to discuss in terms of property or debts. So that's fortunate.
Okay. All right. I guess what I would do then, I know you've got some matters still proceeding before a friend of the court in a couple months in March.
We do.
So I think what the court will do is I'll set this for a final hearing. It looks like by April we'll be past the 6-month waiting period. So I'll set it for a final hearing in April. If there are still matters regarding custody and support and so forth, then we can push things out. But if those things are resolved in March, then we would have a date to be able to finalize things. Do you have any objection to that?
I do not. Thank you, Your Honor.
Okay. And then the court will, I'll note for the record that Mr. Lee did not appear today. I think that would be, grounds for default. He's, he did file an answer, but if he's not appearing today, that's an issue from my standpoint. In terms of his ability to further contest issues, but I'll leave that to you, counsel, as to whether you want to go that route or not.
Thank you.
But I will note for the record that he was provided notice of the date and time of today's hearing. He did not appear. And then we'll send out to all parties that final hearing in April.
Very well. Thank you again, Your Honor.
Yep. Anything else I can address for your side today?
No, thank you.
Okay. Thank you. That's all for today. You're free to disconnect.
Thank you. Bye-bye.
Bye. Purpose of this hearing today is to address issues relating to property of the marriage, so the division of any assets or debts. And I just trying to get a sense of whether you've been able to make agreements on those types of things or whether we need to set some proceedings to get those resolved. Ms. Webb, as the plaintiff, can you tell me where things are at in terms of dividing up assets or debts of the marriage?
Oh, yeah, they've been, Your Honor, they've already been divided up for a few years now.
Okay, so you guys have agreed on those. There aren't any issues that need to be decided?
Yes, sir. Honor.
Mr. Webb, would you agree with that as well?
Yes, Your Honor.
Okay. All right. And I know that back in December, there was an order, recommended order issued by the referee. Are either of you going to be objecting to those, any of that as we go forward?
So we had a update that we would like to make to it, if that's okay. We were wondering if we could do an agreed upon child support.
So there is a way to address that. And that's something that you're gonna want to contact the friend of the court.
Okay.
And then they can direct you further on how to get that resolved, because it does look like that is still a matter that hasn't been decided or calculated. But there's a very specific statute that governs the payment of child support, and so there's a process, and it'd be easier for the friend of the court to explain that to you.
Okay, perfect.
Where you can ask questions and stuff off the record. So what I'm going to do, this was filed in October, so as you both may be aware, there's a 6-month waiting period before the court can finalize the divorce when minor children are involved. So what I can do is set this for a final hearing in April. And what the two of you will need to do prior to that hearing is, number one, contact a friend of the court, get the child support issue squared away, and then they will provide you with a final child support order that will need to be filed prior to that final hearing date.
Okay.
And then the only other thing that you would need to do is, there's a form called a judgment of divorce, and that's available where all the other forms are related to the divorce. That's the final document that has to be signed by the court to finalize things. So I'll need you to get that judgment of divorce form, fill that out, and submit that to the court also prior to that final hearing date. If we have all of those documents, then we can finalize things on that date in April. And the court will send you both a notice of the date and time of that hearing. It'll be by Zoom, just like we're doing today. And again, we'll send you that in the mail so that you know when that date is. Ms. Webb, do you have any questions at all?
No, Your Honor.
Mr. Webb, do you have any questions?
No, Your Honor.
Ms. Kraus, do they just need to call up to friend of the court to address that issue of child support?
Yes, they would just need to ask to speak to their case manager, Tara, I believe.
Okay. Okay, great. Thank you. That's all for today, and you're both free to disconnect at this time.
Perfect.
right.
Thank you, Your Honor.
Thank you. Have a great day.
Okay, ma'am, are you Hannah Peters?
I am.
Okay, we're on the record in Peters versus Peters. This is case number 2419704. The record should reflect that the plaintiff, Ms. Peters, is present here before the court today. This hearing was set for 10:15. It's now 10:22. I do not see Mr. Peters appearing in the Zoom waiting room. Have you had any contact with him recently?
Yeah, actually, my girls were just downstate with their family, and I talked to him on Friday, and we talked about the court date, and he asked me what time it was. I told him, and then we actually talked yesterday morning about it as well, and confirmed that it was at 10:15. And I just messaged him and to see where he was, and just to remind him, and I have not heard anything from him. I actually I texted his mom as well, because I am in contact with his mom, and I have not heard anything from her either. So,
okay.
I don't know.
All right. Well, I've got a couple questions for you, because I know that you've had some proceedings in the front of the court regarding custody and parenting time and so forth. The purpose of this hearing today is to determine whether or not there are any issues regarding the division of any property or assets or debts of the marriage. From your standpoint, have you guys been able to make any agreements on that, or are there
We don't. I'm sorry, we don't have any assets or anything together. The only thing we had, it's been years, but we don't have anything now. No debts or anything like that.
So nothing to divide, basically.
No, and we've actually been on good terms. So we've communicated really well with each other and tried to figure out the best situation for the kids and this whole thing. So we don't really have anything we're fighting over or that we need to discuss.
Okay, and the order that was issued regarding custody and parenting time, it looks like that's final order that was issued. So, I mean, this was filed back in May. There's a 6-month waiting period that expired in November. So we can finalize the divorce at any time if you guys are ready. There's
I mean, I think we would love that. I don't know where he is right now, and I was hoping that he would be here considering I talked to him yesterday morning, but he is not here. So we've agreed to everything though. So
okay. We wouldn't be able to finalize it today anyway, because there's a couple documents that I'm going to let you know about right now that need to be submitted to the court prior to the final hearing date. So one of those is a final order regarding child support, and that's something that you can get from the friend of the court.
I think I did. Is it the one where you fill out all your information like work and your income and all that?
That is for them to determine the amount of child support, but there'll be a final order that says what the support is.
Okay, because I did submit that on Friday. I'm not sure if he did on his end, but I did get all information from him as well. So a lot of it was the same questions. So I just need the final order, and then what else?
And then there's a form called the judgment of divorce.
Okay.
And that is something that you can find that where you found all the other forms that you have for the divorce. That's the final document that the court has to sign to finalize the divorce. It's called the judgment of divorce. So if you can contact a friend of the court and then get that judgment of divorce form on your own, get all that filled out and submit that to the court, I will send out a notice to both of you of the date and time of that final hearing. It'll be by Zoom like we're doing today. And then if those 2 documents are submitted, then we can finalize it on that date.
Sounds good.
One question I have, Ms. Kraus, are you there? Hi, can you tell me, is the support something that would be able to get wrapped up in the next 30 days? Or it sounds like maybe that's just something that is just getting looked at.
Let me look. It's not my assigned case, but let me look to see if the information has been received. If you give me just a moment.
Sure.
Your Honor, the other case manager just stopped into my office to indicate that the review is actually going out in the mail today.
Okay, so if I set this for a final hearing in 30 days, that'll be enough time?
Yes.
Okay. All right. So again, Ms. Peters, we're going to try and get this set for February, but you'll get notice of the exact date and time of the hearing for that. Okay.
All right. Sounds good. Thank you.
Okay. Thank you. You're free to disconnect. Okay, looks like we have counsel connected. We'll go on the record in Vander Kirkhoff versus Vander Kirkhoff. This is case number 2419800. If I can have both counsel put your appearances on, starting with plaintiff, please.
Reagan Richards, Legal Services of Northern Michigan, on behalf of plaintiff Haley Van Diekerchove.
Oh, Mr. Blumberg, you're muted.
Sorry about that. So unlike me. For the record, Judge, Mr. Vander Kirkhoff is appearing via Zoom from my office.
Okay, all right, this is set here today. It looks like we've got Ms. Richards, your objection to referee's recommended order, is that correct?
That is correct, Your Honor.
Okay. Ms. Richards, can you tell me how long was the hearing before the referee on this?
The hearing before the referee was, I believe, 3 hours.
Okay.
Yeah, that's correct.
All right. So Ms. Richards, in terms of de novo reviews on objections, the court, pursuant to court rule, limits the proofs to either new evidence that's come up since the date of the referee hearing, or to new witnesses that, because of time limits, were unable to testify at the referee hearing. So with those kind of limitations in mind, how much time do you think we would need for additional hearing in this case?
I believe a half day as well, same amount of time as the evidentiary hearing.
Okay, Mr. Blumberg?
I think it might be safer to block off a full day, Judge. I mean, I'm not sure we can get it done in a half a day.
Okay. Ms. Richards, do you have any objection to that?
No, Your Honor, that's fine with me.
Okay. Ms. Richards, do you need any particular period of time to be ready for that hearing, or should the court just set it for its next available date?
I think the next available date is fine, Your Honor.
Mr. Blumberg?
That's fine, Judge. I guess I would just ask the court to require the parties to file a witness and exhibit list in advance of that.
Okay. All right. So the court will set it for a full day hearing at its next available date, which I expect it's going to be at least 30 days out. The court will order that both sides exchange witness and exhibit lists 14 days prior to the hearing date, once that's set, and provide the court with a copy of those lists as well. Ms. Richards, anything else that I can address for your side?
No, Your Honor, thank you.
Mr. Blumberg?
No, Judge, I think we're all set. Thank you.
Okay, the court will send out notice of the date and time of that full day hearing. And that's all. Both parties are free to disconnect. Although, Mr. Blumberg, I'm just going to put you in the waiting room for a minute. I think you have the next hearing up as well.
I do. Thanks, Judge.
Thank you, Your Honor.
Okay, we'll be in touch. I'll let you know when we get the hearing.
Okay, looks like we've got both counsel connected. So we'll go on the record in DeGrez versus Dash, case number 2419634. And if I could have both counsel put your appearances on.
Thank you. Miranda Bailey Quick on behalf of Rebecca DeGrez.
Morning again, Judge Elliott Blumberg on behalf of James Dash, who is appearing via Zoom.
Thank you. The record should reflect both parties are present by Zoom. Mr. Blumberg, this is your motion regarding a mediation agreement that was reached by the parties. You're asking the court, I think the gist of it is basically to enforce that. The parties agreed to it, and is that kind of it?
Well, it is kind of it, Judge. Actually, we're asking the court to incorporate that in the form of an order so that it would become enforceable and perhaps punishable by contempt should either of the parties not follow the terms of the agreement. I filed this motion on December 9th, I believe. I think I received a response from Miss Bailey Quick this morning. I don't think she's objecting to the preparation of an order. I think we have well, I guess what I gather from that is the parties agree an order should enter. We just need to prepare an order that's agreeable and present it to the court for signature.
Okay, Ms. Bailey Quick.
That is correct. I have spoke with my client and we are in agreement. I think we just need to agree on the form of what the order looks like.
Okay. I don't know where to go with that. I'm not sure where the disagreement is in the wording or.
Well, to be candid with the court, because I just attempted to copy what the mediation provisions were. It didn't have all the normal standard language one would find in a custody order. So I didn't want to overstep what I was asking for. What I received, and again, I haven't even had a chance to review all of Ms. Bailey Quick's proposed order. She's got stuff in there clearly that would be in there in a normal custody order. I think if the court gives us an opportunity, we can probably come to an agreement quickly and present it to the court that way.
Okay, Ms. Bailey Quick, do you have any objection to that?
I don't, and I tried to, I was scheduled to meet with my client right after Mr. Blumberg filed his motion to review his proposed order with her, and I prepared what I filed with the court and I prepared that to review with my client right after Mr. Blumberg filed his motion. Unfortunately, she had a death in her family and missed that meeting. And then with the holidays, she just wasn't able to connect with me. And so I decided I would just file it this morning so that Mr. Blumberg could see what I was proposing. So I think if we just had a little bit of time that we could agree. There's just never been a formal final order ultimately entered in this case. And I think it just needs to have a final full order entered.
Okay. All right. I mean, I think the important thing is nobody's challenging the substantive terms of the agreement. So it's just a matter of the form. This is the type of thing that I would expect counsel to be able to agree on. So I guess, Mr. Blumberg, I'm just going to hold your motion in abeyance for today's purposes. To the extent that you aren't able to agree on form, I'll just ask you to renotice it for another hearing. And if that's the case, I mean, the parties have already kind of done it, but to the extent that you would need to file different or additional orders, then the court would review the submitted orders and determine which one was more appropriate.
That's fine, Judge. The substantive findings of the mediator were agreed upon, so we're not changing the terms. It's just, I just haven't had a chance to look at what was presented to me this morning.
Okay. All right. I guess that's all I have for today. So all parties are free to disconnect at this time.
Thank you.
Thank you.
Ma'am, can you tell me what case you're signing in on and what your name is?
Oh, it's Janine Jarvis.
Oh, Ms. Jarvis. Okay. I wasn't sure because it's signed
Yeah,
under
I'm using
Vicky.
a coworker's computer.
Oh, okay. Gotcha. All right. Have you had any contact with Mr. Jarvis? Do you know if he's going to be joining us?
I don't know if he's going to be here or not.
Okay. Okay, the person joining us on the phone, last four digits, 7736. Can you tell me your name, please?
Brock Lehman.
Mr. Lehman? Okay. Mr. Lehman, I've got your hearing at 11:15, so I'm just going to put you back on hold until then, okay?
All right, thank you so much.
Thank you. Okay, so we'll go on the record in Jarvis versus Jarvis. This is case number 2419846. The record should reflect that Ms. Jarvis is present today by Zoom video. This hearing was set for 11 a.m. It's now 11:03. Mr. Jarvis has not appeared. And it looks like there has been a proposed judgment of divorce submitted that appears to have been signed by both parties. Ms. Jarvis, did you want to proceed with finalizing the divorce today?
Yes, please.
Okay. I'm going to have you raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You can lower your hand. Ms. Jarvis, I'm going to ask you a series of questions. The questions that I'm going to be asking you are those that I'm required to ask to establish the grounds for divorce under Michigan law. My first question is, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time that you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true when you signed the complaint?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No.
Are you currently pregnant?
Am I what?
Are you currently pregnant?
No.
The judgment of divorce provides that you are not going to receive any alimony or spousal support. You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Do you own any real estate or real property with Mr. Jarvis?
No.
And have the two of you already divided up all the debts and property between the two of you?
Yes.
Are there any issues remaining regarding the division of assets or debts that need to be decided by the court?
No.
And you're asking to have your last name changed to Adkins, is that correct?
Yes.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Ms. Jarvis. As I indicated, now it's 11:05. Mr. Jarvis still has not signed in. However, the proposed judgment does purport to bear his signature as well as that of Ms. Jarvis. The court will sign that judgment. So Ms. Jarvis, your divorce is finalized as of today. That means that going forward, your last name will be changed to Adkins. So you'll need to make changes to your identification and other documents, okay?
Yep.
Do you have any questions at all for me?
No. Do I get a copy of that in the mail or do I pick it up?
It looks like I don't see a return envelope, so you would need to stop in and get a copy of that.
Okay.
And you're probably gonna want to do that because you'll need to show that to Secretary of State and anywhere else
Right.
where you want to.
Okay.
So,
It'll be ready by tomorrow.
okay, and it'll be ready for pickup tomorrow.
Okay. I'll stop in.
Okay,
Thank
thank you. That's
you.
all. You're free to disconnect at this time.
All right. Thank you.
In this emotional courtroom moment, a father fights to keep seeing his 4-year-old son after losing parenting time in a heated custody battle. Standing before the judge over Zoom, he admits there's already a court order in place, but insists he never meant to violate it. He tells the court that he raised his son every single day, took him to work, cared for him constantly, and now feels like his entire life is being ripped away. At one point, his voice cracks as he says, "This is killing me, and it's hurting my son." But the judge has serious concerns. The father previously failed to return the child when ordered, and the court worries the same thing could happen again. Then the mother's attorney pushes back hard, arguing the father knew exactly what he was doing and ignored the order on purpose. According to the attorney, this wasn't confusion, it was defiance. Now the judge must decide what matters more: a father begging for another chance, or protecting the court order already in place. And that leaves one difficult question. If you were the judge, would you restore his parenting time or keep the restrictions in place? Like and subscribe for more real courtroom moments.